this morning is State of Ohio versus Erin Jones. Each party will have 15 minutes in which to present the case. If you, the appellant, wish to retain some of that time, let me know when you come up to the podium. And keeping track of the clock and keep you apprised of the passage of time. We are being visually and audibly recorded and posted online, so please try to remain behind the podium as much as possible. We had read your briefs and are ready to proceed with your work.
Thank you. Good morning, Your Honors. May it please the Court, my name is David Sheldon. I represent Erin Jones, the appellant in this matter, and I'd like to respectfully request 3 minutes for rebuttal time.
Thank you.
Thank you. I'm going to focus my arguments on assignments of errors number 1 and number 3. Obviously, assignment of error is not applicable unless this Court finds that certain things were kept out of evidence and therefore there was not sufficient evidence. With respect to the first assignment of error, the appellant in this case is challenging the admissibility in the judge's ruling, the trial judge's ruling on the motion to suppress the admissibility of the urine sample in this particular case. As this Court is aware, following this particular accident, my client was taken to the hospital and a urine sample was obtained by Trooper Bissonette pursuant to the Ohio Administrative Code. Everything appeared to be regular about taking that urine sample, except Trooper Bissonette testified at the suppression hearing that he added a sulfate mixture, quote-unquote sulfate mixture, to the urine sample and sealed the container and then sent it off to the laboratory for testing. The appellant does not have an issue with the testing process. The appellant does not have an issue with the collection of that sample. Everything seems to have been done in accordance with the Ohio Administrative Code. But this whole issue of the sulfate mixture is what I'm focusing on assignment error number 1. The Ohio Administrative Code, as you know, used to contain a provision that when collecting a urine sample, they were to, the collecting officer, or whoever was collecting the sample, was to include a sodium fluoride tablet. Sodium thymol fluoride tablet in there. That language was removed from the administrative code. The code is now silent on adding anything to the urine sample. So under Burnside, which I stated, which this Court knows, under Burnside, in order to challenge admissibility of a test result, whether it be alcohol or urine, it's incumbent upon the appellant or the defendant to file a motion to suppress and challenge those results. That's what was done in this case. So the burden is upon the state of Ohio to show substantial compliance with the Ohio Administrative Code. And I cited Burnside and the other case out of the Ninth Cutlip for the proposition, even though we're dealing with urine and not alcohol or blood, is that in the situation with blood, the statute says that they shall add a solid anticoagulant. Well, I believe it's axiomatic if the statute or the ordinance, in this case the administrative code, is silent on adding anything. I think it becomes axiomatic that if you do add something, you're adulterating the sample. And I cited those cases for that proposition. You know, Trooper Bissonette said he inserted a sulfate mixture. The state of Ohio went to great lengths in its response brief, merit brief, to say, well, what Trooper Bissonette was really talking about was this sodium thymol tablet that was previously allowed under the administrative code to be added. Well, we can't speculate. You can't make up evidence. Trooper Bissonette never testified about, you know, all he said was a sulfate mixture. And it's not incumbent upon the defense to say, well, whatever it was, it didn't harm the sample. That's not the burden on the defense. The burden's on the state of Ohio to show substantial compliance with the administrative code, which they didn't, because the code doesn't say you're allowed to add anything to that particular sample. And the state wants the court to speculate that really what happened here is this trooper added really a sodium thymol fluoride tablet to the sample when there's no testimony, no evidence to support it. That's mere speculation.
Counsel, if the trooper had specifically said sodium, whatever, the language from the old code, instead of sulfate, I guess I want to make clear what your argument is, because initially, sometime just maybe 60 seconds ago, you said it's axiomatic that since it's silent, basically they shouldn't be adding anything. So would it have made a difference whether he testified to a sulfate or to the exact tablet that they used to, that used to be included in the code? Did my question make any sense to you?
Yes, Your Honor, yeah, it did. I think if the trooper Bissonnette had testified that he put in a sodium thymol fluoride tablet, which was previously allowed or was mandated, then I think the burden would shift to the defense to show, well, okay, if he put that in there, Mr. Sheldon, can you show what effect that had on, if any, upon the urine sample that was tested? That, I believe, then would shift the burden to the defense to say, hey, this was added, this was previously allowed, but it was taken out of the administrative code. What effect, if any, did that have on the sample? But that's not the burden of the defense, because the burden of the defense is to challenge the admissibility of the urine sample, which is what Mr. Callow did, the trial counsel did through the motion to suppress. So there's no burden upon the defendant to say what, if any, effect do we know what a sulfate mixture is? I mean, none of us know what that is. We don't know what that means. So if it was added, and what if in the realm of possibilities it increased the alcohol content? Well, that's a substantial factor because she tested over the legal limit. And that was a big argument by the state in closing arguments, that she committed aggravated homicide as a result, or approximate cause of committing OVI either under the influence, operating that vehicle under the influence of alcohol, or having a prohibited concentration of alcohol in her urine, which the test results show she did. So for those reasons, I don't believe that the state has a legitimate argument that this was a sodium thymol tablet to shift the burden to me. We don't know what a sulfate mixture is or what effect it had on that particular sample. For those reasons,
Can I ask you a question about that, though? I thought that I read somewhere that the examiner, the person who performed the analysis at BCI, or whoever received the urine, he testified at the trial, is that correct?
yes, he did.
And was he asked about, was it contaminated with some sodium mixture or sulfate mixture?
That question was never asked.
So no one on defense asked, was it tainted in any way? He never presented any evidence that it was tainted in any way?
No, but I don't think it's the burden on the defense to show that it was tainted in any way. I think it's the burden on the state of Ohio to prove beyond a reasonable doubt that that sulfate mixture that was added, which he didn't testify about, had no effect upon the urine sample test result. That issue never came up through the BCI analyst that tested the sample. So,
One more question. In terms of the suppression hearing and the challenge to the addition to the urine sample, was that actually challenged at the suppression hearing in terms of the compliance, or no, I guess I should say non-compliance?
no, Your Honor. Trial counsel did not specifically raise the argument that I'm raising here before the Court of Appeals, but again, I think it's sufficient that he's filed that motion and raised the substantial compliance argument. That it's the burden upon the state of Ohio. They have to substantially comply with the administrative code, even though he didn't specifically argue, hey, trial judge or trooper Bissonnette, you put the sulfate mixture in here, you contaminated this, didn't you? He didn't raise that, but I don't think he had to raise that in order to preserve the issue for appeal. And I disagree with Mr. Vigliucci's argument that it's a plain error analysis since I waived it. I don't believe it's a waiver because he's raised that, trial counsel raised that by the motion to suppress and putting the state to its burden of proof. So for those reasons, I would respectfully request that the court grant or reverse the trial court's ruling on the motion to suppress, finding that the addition of a sulfate mixture was an adulterant and failed to substantially comply with the Ohio administrative code, therefore rendering the test result unreliable and inadmissible and should have been suppressed, therefore rendering the jury's verdict on this count reversible error. With respect to issue number 3, that other issue in this case is the 2 aggravated vehicular homicide counts in this case were identical. And neither one of the jury verdict forms indicated the degree of the offense or any elements of the offense for either one of those counts.
But they weren't really identical, were they? I mean, their elements weren't identical.
Well, you looking at the jury verdict forms, you don't know.
But
If you just look at the verdict forms, there's no idea, there's no distinction between either verdict form as to aggravated vehicular homicide. But there is a distinction under the statute, and there was a distinction that the trial court read in the jury instructions.
that was my
but there's no distinction in the verdict forms. So under State versus Pelfrey, the House Supreme Court case, I mean, that language is pretty specific in Pelfrey, and if we're to strictly construe that statute, which specifically states, quote, a verdict form signed by a jury must include either the degree of the offense of which the defendant is convicted or a statement that an aggravating element has been found to justify convicting a defendant of a greater degree of a criminal offense, close quote. And that's the language of Pelfrey, and that's the language I relied upon because neither one of these verdict forms, either one of the aggravated vehicular homicide verdict forms make any distinction between the two charges, none whatsoever. There's no language as a proximate cause of committing an OVI, which would make it a greater degree than recklessly, because recklessly is a lower degree. Recklessly is a felony of the third degree, while aggravated causing the death of another as a result of approximate cause of committing an OVI is a felony in the second degree. So we don't have that distinction here. And under Pelfrey, in the cases I cited in my reply, in my rebuttal brief, State versus Peak, which is also a Wayne County case, that was a little bit different. That was a violation of protection order, again, but the verdict form did not specify any degree or any elements that would have enhanced the offense, and therefore, under those cases, it becomes the offense of the least degree, which in this case would be vehicular manslaughter, misdemeanor of the second degree. And so for those reasons, I would respectfully request that the court find that based on the jury verdict forms as to ag vehicular homicide as well as the vehicular assault, and ag vehicular assault, again, there was no distinction between the ag vehicular assault and the vehicular assault charges, except in name only, but nothing in terms of degree or nothing in terms of any element that made one more serious than the other. So under the ag vehicular assault and vehicular assault charges, those would become, oddly enough, misdemeanors of the first degree, because those would be the least serious offense in question. So I'd ask the court to reverse and find that the jury verdict forms in this case should be reduced to vehicular assault or vehicular manslaughter, misdemeanor of the second degree, and vehicular assault, misdemeanor of the first degree. With respect to, and then finally with respect to assignment of error number 2, all right, with respect to assignment of error number 2, without the urine evidence in this particular case, there would not be sufficient evidence to convict on that particular count if the jury is basing it on operating a vehicle as a result of having a prohibited concentration of alcohol in her urine, which was the argument made in closing argument by counsel. So for those reasons, I respectfully request to reverse on count number, or based on assignment error number 2, remand this matter to the trial court for further proceedings. Thank you.
Good morning, Your Honors. May it please the court, I'm Vince Bellucci with the Medina County Prosecutor's Office for the appellee in the state of Ohio. I will just jump right to the urine alcohol test as well. That's what Mr. Sheldon seems to have focused on. So, first of all, I don't think you can compare blood to urine. They're completely different standards, completely different substances. There is something that's required to be added to blood still to this day. Not so with urine, but that did used to be the case with the SFT tablet, as I think I explained pretty thoroughly in the brief. But specifically that Topolowski case I cited, they really get into it and really, because they consider this exact same argument. And they did get into the whole history of this and why it's in the State Highway Patrol kit. And personally, I was actually able to get a hold of one of those kits and look at it and see what this even looks like. Because this did pique my interest, certainly when I saw Mr. Sheldon's argument. I guess the argument now is that the word sulfate. If it is the SFT, I don't think there's any way he can prove that it contaminated the sample, which I think is his burden to do so. If you read the Topolowski case, they clearly find that to be the case. The defendant would have to show that it contaminated it in some way, and could not do that in that case, and cannot do it here. In fact, if you look at the 5th District case, the Neal case, they actually talk about why this is they talk about sodium fluoride as improving the quality of the sample. preventing the fermentation of sugar to ethanol at room temperature, which I don't know what all that means, but when they say improving the quality of the sample, that's the opposite of contaminating the sample. It's actually making it better. This was required to be, before 1997, the OAC required this to be added. And if you look at sodium fluoride, I believe, is a sulfate. So I don't think it's completely out of left field to presume that that's what the trooper was talking about. You see in other parts of the transcript, he talks about how he had just worked a shift the night before. We see this in the context of when he's describing the field sobriety test as well. He slightly misspeaks in a few places. He said he'd been up for over 24 hours. He had just worked the night shift. He had been subpoenaed to come in to testify. This is another case of him, I think, simply misspeaking. Or perhaps not. Maybe he does generally describe the SFT tablet as sulfate. I don't think that's hard to envision either when you look at this. And I think the standard of review is plain error because while there was a motion to suppress raised at the trial court that did challenge the urine alcohol test, it did not raise this argument at all about this sulfate. So that's what makes it plain error. And that certainly means that he has to prove that it was contaminated if we're talking about plain error here. And I don't think it's something that you have to be on Lexis to figure this out either. If you go on the State Highway Patrol's website, it actually says urine, add sodium fluoride, parentheses, preservative, maintain sample integrity. So this is clearly still to this day what they tell their troopers to do. This is what's on their website as their standard operating procedure is to add this. It is still in the kits to this day. And I agree, the OAC is silent on this today, but that doesn't mean you can read into the statute language prohibiting it. That's not what you do. It doesn't prohibit it, so that means that they can do this, I think. Now, just in terms of third assignment of error, the verdict forms, ag vehicular assault and ag vehicular homicide, these are not offenses where one or more elements makes the offense more serious. The specific sections that were charged in this case, there's 4 different ones. There's 2 statutes, but 4 different sections within those statutes are completely different offenses. They have completely different elements. They have fixed levels. They cannot go up and down. The jury has to either find you guilty or not guilty of these. Pelfrey is the total opposite of that. You had a tampering with records case in which under 291342, specifically B2A, it would have just been a misdemeanor. They were just tampering with any old record. But there's the additional element that the records are government records, and that elevates it to a 3rd-degree felony when you're looking at the penalty sections. In that case, the verdict forms and the trial court's ultimate entry both did not mention the degree of the offense and didn't mention that the records involved were government records. This is totally different. In fact, that's the minority to where I think Pelfrey would come into play. You look at the numerous cases I cited in which Pelfrey doesn't apply: rape, GSI, kidnapping, ag robbery, ag burglary, all these kind of crimes. There's no enhancement. You're either guilty of it or you're not. That's why you haven't seen this big wave of these things being overturned. Generally, the verdict forms I've seen do not specify the exact code section or what the element or what the level of the crime is. In fact, you're not allowed to tell the jury the level of the offense. So that's why these jury forms don't say F1, F2, F3, F4, because they don't want to get in trouble there on that side of things. So I'd also mention, just in terms of the, I know the manifest weight, the assignment of error 2 pretty much relies totally on the urine test being thrown out, which I've said should not be. But even without that urine test, I would just mention there was a mountain of evidence in this case to convict Ms. Jones. That would not, even if that was thrown out, that was only one piece of evidence, and it was a big piece of evidence. It showed that her blood alcohol content was twice the legal limit, or I should say almost twice the legal limit. But there was also evidence that as a result of the crash, the victim and a child, well, the adult was killed and the child was seriously injured with a broken femur, fractured femur. Jones admitted that she caused the crash, admitted that she drank heavily on the night in question. Accident reconstruction confirmed that she caused the crash, which caused a chain reaction, subsequent crashes. The data recorder in her vehicle actually showed that at the time of impact, she was driving 110 miles an hour at the time of impact. So a lot of evidence in this case. The field sobriety tests I know are mentioned. She exhibits 6 out of 6 clues on the HGN, 4 out of 8 clues on the walk and turn. She's exhibiting 3 out of 4 on the one-leg stand. She's showing a lack of convergence. And I think the video is very important when you're looking at the field sobriety tests because I think the officer did misspeak on a couple of those. And if you look at the whole context of it, the way he's talking, when he says, he moves on to the next one, he says once again, and then he starts talking about 12 to 15 inches. He starts saying slightly above eye level, as if he had just testified that previously. So I think if you look at the whole context, that he was misspeaking the first time. And if you look at the video, he really is, I think you'll see that he's doing those field sobriety tests properly in accordance with the NHTSA manual. There's the observation of an alcoholic beverage coming from Jones, as well as bloodshot eyes. There's the whole circumstances of the case that she said that she's left a bar in Cleveland and somehow ended up an hour and a half away near Mansfield, trying to get home to Avon Lake on the west side of Cleveland. Not something that generally happens to somebody who's not intoxicated. I would just point that out as well. So in terms of the instructions, I think you'll see on the video, the instructions on the field sobriety tests, there were instructions given. I think there were proper instructions by the trooper. There was even a demonstration, and I think they were in accordance with what he testified to in the hearing. So that's really about all I have. If there are no questions, I would just respectfully ask this court to affirm the judgment of the trial court. Thank you.
Thank you. About 2.5 minutes, Attorney Sheldon.
Thank you. Very briefly, Your Honors, with respect to the prosecution's argument that the Topolowski case is on point with this addition of quote-unquote a sulfate mixture, therefore it's really sodium fluoride. We don't know that. I mean, anyone could go online and look up things and start speculating this is what the trooper meant or didn't mean, or where he got this sulfate mixture from. We don't know that. So we're not here to speculate and create facts where none exist. That's not a fair inference from the facts of this case because we simply don't know what Trooper Bissonette meant by sulfate mixture or where he got that sulfate mixture from. So Topolowski from Franklin County, the 2015 case cited by Mr. Lucci, is not applicable, not persuasive authority in this case, nor does it have any relevance in terms of the actual adulterant in this case. So for those reasons, I would ask the court to respectfully reverse the decision of the trial. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be posted on our website, that is Supreme Court.